Hello friends, today we are going to discuss about Bolam Test. I'm Dr. Suresh Badadmat, Professor of Psychiatry, working at Nimans, Bangalore. Before I start my presentation, I would like to have a disclaimer. This presentation is for academic and training purpose only. If you want to have a legal opinion, please do contact an advocate. Conflict of interest? None. Let's understand what is Bolam's test, why it is used, whether it is accepted in Indian courts, and let's critically evaluate this Bolam's test. What is this Bolam test? This is a test that arose from English tort law, which is used to assess the medical negligence. That means, first time in the world, the English court discussed about Bolam test actually. So let's understand about this Bolam. Bolam test holds that law imposes a duty of care between a doctor and his patient. But the standard of the care is a matter of medical judgment. That means, Bolam test clearly said that there is a duty of care that a doctor owes to his patient. And the duty needs to have a standard of care. That standard of care will be decided by the medical fraternity. This is how the Bolam test is put across. Now let's understand how this Bolam test originated. So, Mr. Bolam had recurrent depression and hence he went to a hospital, that is Friern Hospital Management. So here he used to take treatment. Please do remember this case happened in 1957 and this is a landmark English tort case with regard to medical negligence. And this is the case and the test used across the world to assess medical negligence. My dear friends, now let's discuss about Bolam versus Friern Hospital Management Committee 1957 case. So as I mentioned, Bolam was a voluntary patient who was suffering from depression. And hence, in one of the episodes, he became severely depressed. And the doctors said that you need to take electroconvulsive therapy. And electroconvulsive therapy is nothing but shock treatment, which is generally in colloquial language it is spoken. So Bolam agreed to take electroconvulsive therapy. And during 1957, unmodified ECT was the norm. So there was no muscle relaxant given, no anesthesia was given, he was not even restrained during the procedure. In the first seizure, nothing happened. And in the second seizure, nothing happened. In third or fourth seizure, he sustained fracture of acetabulum. See, usually the ECTs are given on alternate days. That means on the sixth day, when he received the third ECT, he sustained fracture. By that time, Bolam had recovered from depression. He became angry with the hospital that I came for treatment of depression. Now my acetabulum has been fractured. So he approached the English court claiming that the doctor in the hospital was negligent. Negligent by not restraining him during electroconvulsive therapy, not giving him muscle relaxant, not giving anesthesia, and also not informing about the risk of acetabular fracture. This was the case put in the English court by Bolam against the Friern Hospital Management Committee. Now, the Judge McNair, for the first time, came to know that a patient can sue the hospital, and he tried to look into the older judgments. There were none. So now, McNair Judge had to decide this case. For a moment, just let us pause here and think. In 1957, if you are the judge, and there is no medical negligence case across the world, and first time it has come to you, that too with regard to psychiatry, which is least understood by the most of the medical fraternity and also the general population. And electroconvulsive therapy is considered as a punishment. In such a scenario, and you being the judge, how will you take the decision? So now in this case, Bolam versus Friern Hospital, Judge McNair was very intelligent. He immediately called for expert opinion. So the expert opinion was divided into two. Some of the experts said that I would like to go ahead with without giving anesthesia, muscle relaxant, and without restraining him, I will give him unmodified ECT. That means without giving any general anesthesia. But however, another group said, sir, giving ECT by giving muscle relaxant anesthesia is highly palatable. I would like to choose that. So now again, Judge McNair in 1957 found that the expert opinion is divided into two groups. So again, Judge McNair thought for a while and came with the landmark judgment which is now also holds good. And he clearly said that the doctors and the Friern Hospital Management Committee is not negligent in providing the care. And in his judgment, he clearly said a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as a proper by a reasonable body of medical men skilled in that particular art. Let's apply this rule in this case. Bolam said that in the Bolam test, the Judge McNair clearly said that doctor will not be held responsible if he is able to follow the standard practices which is accepted at that time. There were two standard practice and the hospital and the doctors followed one of them. Hence, nobody is punishable and no medical negligence could be established. Further, Judge McNair also said if a doctor reaches the standard of responsible body of medical opinion, he is not negligent. So here, the Friern Hospital doctors and the committee were able to meet the standard of care which is required at that point of time in 1957. Hence, the case was dismissed and the Bolam could not get any compensation. And this Bolam test is accepted even in Supreme Court of India. That means it is applicable even in India. It is best example I can give is Jacob Matthew versus State of Punjab. In that case, the Supreme Court clearly says that Bolam test should be used when you are assessing whether a doctor is negligent or not. So this Bolam test is a landmark test used in the medical profession to assess medical negligence. And as I mentioned, my dear friends, even National Consumer Forum uses this Bolam test for assessing medical negligence. But however, let's understand how it is criticized. Bolam test has been criticized telling that the doctors themselves will be assessing his peer about whether he is negligent or not. Hence, it is considered that the doctors will not allow another doctor to be let down in the society or in the court of law. This is the biggest criticism of Bolam test, telling that the doctor will never say his fellow colleague is negligent. This is one of the criticism, and hence many of the other courts recently there is a new test has been taken, that is Patrico-Bolith test. I'll be discussing about Bolitho test shortly in another video. Please follow my channel to know about Bolitho test. So, to conclude, my dear friends, a doctor must demonstrate that he has acted in a manner in which a responsible body of medical profession who work in the same field would deem that it was a reasonable and appropriate. And criticism is, it is a peer review, hence it is criticized. Summarizing, a failure to match up to a required standard of care is considered as medical negligence, and peer review test is not acceptable to the society, hence it is criticized. Thank you for giving your valuable time. Stay safe.